Hello, everyone. Welcome to today's session on prepping for the July 2020 OSCE. A little introduction to the speakers before we move on to our webinar. My name is Priyasha, and I'm a corporate lawyer based in the UAE. I qualified as a solicitor in 2018. My co-speaker for today is Asta, and she's a legal and regulatory lawyer based in Germany, and she qualified as a solicitor in 2019.
Hello, everyone.
Yeah, so today we're here to share our experiences and share our tips as well for what we thought worked for OSCE. Great. So just a little bit about QLTS Geek before we dive into the agenda for today. So QLTS Geek is a web and mobile app which is aimed at helping candidates with, QLTS candidates with bite-sized information for the assessments. We're actually working on rebuilding the mobile app, and unfortunately, due to technical issues, we haven't been able to release it yet. But we're hoping to release the mobile app very soon. Please follow us on LinkedIn, Facebook, or Instagram for updates. So watch this space. Great, so let's jump right into the agenda for today. We're gonna first cover how to study SMART for the OSCE. The OSCE is a bit of a different animal to tackle, so you definitely need to tailor your approach. We're also going to take you through each of the 6 assessments that you will be subjected to for the OSCE, and we're going to give you tips for each of them. We're going to then cover the OSCE marking criteria as well, because it's useful to know what the marking criteria is before you take the assessment. And finally, we're also going to share a few tips for the D-Day. Great, so how do we study SMART for the OSCE? Now, one of the mistakes that I see a lot of candidates make is that they leave the practicing of the mocks to the very end. So essentially, a lot of candidates, they want to cover their coursework. So especially if you're reading the OEP books, it can essentially take forever. So if you're stuck with reading the books, then what happens is you never really end up reaching the marks. So one of the things that if you haven't done yet, we would strongly advise you to start practicing the mocks, because the OSCE assessment is a very practical exam. You would have to, there's a lot of emphasis on time management. You would also need to, it's also, it's not exactly what you would also encounter in your regular day-to-day life, you know, like having to write something in 20 minutes. That's not really something you would face in your day-to-day, you know, working life. And so it's important that you need to practice all of these things before you actually take the assessment. So I would suggest that, you know, every day try and practice at least one client interview or one assessment from part 2 as well, if you haven't yet started practicing. In fact, now that we're closer to the exam, you could actually do maybe 2 or 3 assessments from part 2 as well. The second tip that I have is to essentially focus on summaries and cheat sheets. Now, the reason why I'm saying this is because, again, if you were to start reading the OEP books, it would take forever because they're quite big and you wouldn't really know what to focus on. So it's very important to understand, to have a bird's eye view of the topic. And then once you have a bird's eye view of the subjects, then you can actually go and supplement your, you know, understanding with the details, and then you can sort of read the books. The third point that I have is to, again, I don't like to give this advice for any assessment, but yes, you do have to memorize certain things for the OSCE, because they're not just testing you on the skills, they're also testing you on the law. So the way you sort of demonstrate that you have a knowledge of the law is by showing off your knowledge, which is by, you know, mentioning case laws at certain points or mentioning certain sections of the law. So just to give you an example, for wills and probate, I would definitely remember that Section 9 of the Wills Act 1837 sets out the formalities of a will. You know, these are the sort of things that I would remember. Even for business law, there are certain sections that I would try to just memorize them, so that if I ever come across a question relating to that, I can at least, you know, cite a few sections and make it seem like, hey, you know what, I actually do know the law. Again, case laws, things like civil litigation, you would actually have to remember the tests, because for a civil advocacy presentation, you might have to cite certain tests. For example, what is the test for obtaining a summary judgment? What is the test for, I don't remember the other stuff at the top of my head, but these are the sort of tests, these are the sort of things that you would have to memorize. So again, I hope you know, you would have your notes on all these things that you would have to keep in mind before you take the assessment. Again, another point that I would again like to emphasize is, you know, your goal is to pass the assessment, especially now that, you know, there are just a couple of weeks left. You know, you don't want to be reading your textbooks threadbare. That would be ideal, but we're not here to be the topper of the assessment. You essentially are here to pass the assessment. So especially if you have limited time left, make sure that you get an overview of the subject, and then you sort of and practice your mocks as well. And then you can actually, whenever you have a little bit of time, you can go into the details, because you don't really have much time left at the moment. So I would say try and focus again, like I said earlier, on summaries and cheat sheets. Another important tip that helped a lot of us was essentially reading the past Silex papers, because a lot of their explanations were very useful. The past Silex papers solutions, they've actually explained the law really well. So if you do read through them, it would really help cement some of the information in your head. So I would definitely recommend checking out the Silex papers and going through going through their solutions.
Priyasha, maybe I can ask you a question about the Silex.
Sure.
So from which years should someone read the Silex papers, from 2018 onwards, or how much one should read from Silex?
Well, that's a good question. I think the issue currently right now with the Silex website as well is that you only have papers for, I think, the last 3 years. So I would say go through, you know, the solutions for each of the last 3 years. That would be good. And then you can also, because a lot of the solutions, you would notice that there is a sort of similar trend, and they've given really detailed explanation for each of these solutions. So that really helps you understand the law.
Yes.
Is that what your experience was? I mean, what did you do?
Yes, I think from Silex, what I did was, from criminal especially, it helped me to focus on the areas which will be tested in the exam. So I know, okay, which test to follow, eyewitness tests, which all the identification tests and so on. So what I did, I took 3 or 4 questions, solutions. I made some notes on for the last minute preparation, and I just looked at those notes just right before the exam. It really did help me a lot to make my own small notes from the Silex, just to reinforce. And also in the exam, as you mentioned, you will not be required to tell everything to the assessor. You have only limited time to tell as much. So I think if you are able to give out the most important points, I think that will really help to cross the line.
Yeah, I think that's a interesting point that you raised, because I would also add to that and say that, you know, in the assessment, you're not supposed to know everything. So at least if you know a little bit, you can at least, you know, talk a bit about it. And you can also mention to the decision maker that, you know, I need to check back, but this is what I know. And because another part about the OSCE is that you don't want to be giving negligent advice. So if you don't know something, you can always tell the assessor that, you know, I'm not sure about this, but I will definitely get back to you once I have an opportunity to check the law or something like that. So yeah, I mean, like I said, this is again an element of trying to study smart. You know, if you don't know the details, you can still give the decision maker an overview, and you can always tell them, I will get back to you on the details.
Did you also have this urge to give a conclusive answer and then you had to resist and not say a conclusive answer that yes, this applies? Or would you want to say a little bit about that? Like for me, I use a tip that I should rather use may more than that you should do this. So yeah, do you have any experience on how to
Yeah,
guide your advice?
yeah, that's again a very good tip. I did make a mistake. I feel like in one of my assessments where I might have given negligent advice because I was, we were sort of meant to interpret accounts, and I'm, of course, as a lawyer, I'm not super great at interpreting accounts. But what happened is, but I learned a lesson from that assessment again, and for my future sort of assessments, I made sure that I, clarified, and I sort of told the assessor that, I'm not sure about this. I will get back to you. And of course, even for things like legal research and those sort of assessments, I would make sure that if I'm not too sure about something, I would say it is likely the case, or use those sort of terms.
Mm-hmm.
This is something that I guess most lawyers who are practicing would also know, because this is what we would do if we don't know a conclusive answer. We would say, we believe that, or in my opinion, or based on the above, this is what we think the situation is going to be. So yeah, I mean, try and again think about those sort of terms that you can use while you're giving advice, or while you're even preparing your letters or research and those sort of things. Well, yeah, I think we can move on. And yes, another thing that I didn't mention before, but if you have any questions, feel free to put it on the chat box, and we will cover it towards the end. And I hope you can hear me as well, because somebody just mentioned that there is an issue with the audio. Or can you hear me, Asta?
I can hear you perfectly fine.
Okay, perfect. Then I think it possibly could just be something with just one of the attendees. Great. So now we're going to go through each of the assessments that you will be subject to for the OSCE. I'm going to cover part 1 of the OSCE, and Asta will cover part 2. So let's start with the client interview. The client interview is something, to be honest, I did find it to be one of the most challenging assessments, because it is slightly different to what you would sort of expect in what you would sort of, encounter in your daily working life. So anyways, I've sort of listed down a few of the tips that really helped me for client interview. Now, the first thing is you're going to be given 10 minutes to prepare for your client interview. Now, the fact is that you don't really need these 10 minutes to go through the question. So what I would suggest is, in fact, you would probably just need a minute to go through the question. So what I would say is that you need to utilize these 10 minutes to actually make the notes for your attendance note. So you're going to be given a sheet of paper with a question, and you'll also be given like a booklet. So what I would say is that for the booklet, you can actually make that as an extra to your attendance note. So in the 10 minutes, try and make the framework for your minutes of the meeting, So let's say that on the first page, what you can do is you can actually write down the contact details of the person who you're meeting, the contact details of the client. So write down name, address, communication preferences, whether they have their AML documents. So you're already writing all of that down in your 10 minutes. Second is, another tip is know your template beforehand, depending on the subject. In fact, you should know your template even before you enter the examination hall. So for example, let's say that it's a wills and probate matter. So you should know what's the template that you're going to follow for your annexure. So what I would do is my first page would be the contact details. Make sure that you know all the information that you need to collect from the client. Second page, I would put, since it's a wills and probate assessment, I would potentially, depending on the question, I would write the details of the deceased. So things like, you know, their name, when they died, when they were born. And then on the third page, I would put like, you know, I would make like a column or whatever style you would like. I would split it into assets and liabilities. And then the next page, I would again have something like a family tree, because this is what generally is the sort of information you would have to collect for, let's say, a wills and probate matter. And of course, you would also know the sort of information you have to collect based on the question that you're provided with. So the advantage of this approach is that you're actually utilizing your your 10 minutes to prepare your framework. So all you have to do when you step into the interview is to jot down the actual details, and you wouldn't have to replicate that again while you're when you're writing your attendance note. Is there any other point that you have here, Asta, for the 10 minutes that you have?
I think let's take a question now, which is related to attendance note. So I'm reading from the chat.
Oh, but attendance note, sorry, hold on. The things that attendance note I'm going to be covering afterwards.
Okay.
Okay.
Yes, I think covered for me. I also did the same. 10 minutes, not just to read the question, but also to make like a format accordingly to the subject. So for example, wills and probate, I would just write very quickly name and just like a format so I know what I'm filling in during the assessment. And then I would also mark it like with an annexure 1, annexure 2 already, so that I save time. And when of course, I think you will come to the interviewing part, but that was my approach as well, just to keep it, attach it later on.
Yeah, exactly. I think, you know, your annexure 1 would be your contact details. Annexure 2 would be, for example, family tree. Annexure 3, details of assets and liabilities. Yeah, exactly. So this sort of helps you, and also putting it in separate pages helps you, because then you don't have to be worried about the amount of space you're leaving in between the different annexures, you know. So you know that, okay, fine, let's say that for some reason you start with the assets and liabilities. All you have to do is just turn to the page where you designated for assets and liabilities, and you can just start noting it down. And as soon as the client talks about family tree, you can actually turn back. So like I said, this 10 minutes is something that you can actually utilize for your attendance note, because attendance note is where a lot of candidates face time management issues. So once you're done with the 10 minutes, then you would be taken to a sort of like a station where you would be meeting your client. Now here again, for the client interview, it sort of helps to know a script, you know, it's like a playbook of sorts, where in your head, you know, you need to follow a certain format. So one is, you know, you can start with your greeting and your small talk. Then second is you sort of also talk about the anti-money laundering documents that you require. Then you also talk about the purpose of the meeting. So purpose of the meeting essentially would be to collect information from the client, and also to give preliminary advice. So during this time, you can use this opportunity to also communicate to the client and tell them that I will not be providing detailed advice at the moment, but I will definitely be collecting all your information. And once we've had a chance to review them, we will provide you detailed advice. And of course, after you clarify that, you go on to collect the information. Now, one of the things when you're collecting information, what you can do, and this is what I did, is that I told the client that, you know, I'm going to be collecting information from you and taking down notes. So please bear with me if I slow you down, or if I, you know, ask you a lot of questions. So this is again an opportunity you have to buy some time and to start writing down your notes. Well, the second tip that I again have is to be friendly, professional, and empathetic. So it's important to be friendly. You need to keep your client, you need to sort of reassure your client. You also need to express empathy depending on the subject. So for example, if it's a wills and probate matter, you might want to tell your client that I understand this is a very difficult time for you, but we're here to take care of the paperwork, things like that. Similarly, in a criminal interview, your client's probably going to be an accused. So you would have to again reassure him or her and tell them that, I will be taking care of the matter. So please don't panic or something like that. Again, the third point is what I just mentioned. Use this time to actually complete your annexure. So you're actually going to be saving so much of time by the time you get back to your room to write your attendance note. So you already have the framework in place, which is name, address. All you have to do is just fill in the blanks. And when you get back to your room, you pretty much have all the minutes of the meeting. Another point that just cropped up in my head is that okay, well, actually, I just forgot about it. But Asta, do you have any other points that you want to add here?
I have a pro tip probably.
Okay.
During the exam, when they give out the blank sheets, to us they only gave out one sheet or two sheet, and I knew that I want to already, like you said, make 3 or 4 separate annexure, because I know when I'm making notes during the interview, I will be like really stressed, and I don't want to like fight for the space where to write it. So I already prepared my annexures according to the format. So annexure 1 in wills and probate, okay, the names, and the second annexure would be of the person who is in question. But they did not give us more than 1 or 2 sheets, but I asked for it. So just if you have a particular format in your head, don't feel like that they will not give you the sheet. They will give you the extra sheets. It's just about asking them prior to going to the interview. So I asked for 4 or 5 sheets. Yeah.
Oh, yeah, that's a useful tip, because you might, in case you want to just have another sheet where you just jot down very, very rough notes.
Yeah.
You can potentially, yeah, you could do that. Yeah, that's an interesting tip. Yeah.
There is a question, Priyasha, on the chat. Do you want to take it now?
Yeah, I'm just trying to think whether it makes sense to take all the questions at the end, right? I think that would sort of be easier. Then we can keep track of time as well. Great. So now we come to the attendance note. The attendance note is actually a different part of your assessment. So client interview was one assessment, attendance note is another. And the interesting part is that if you follow the tips that we mentioned, you would have already scored half of your score for your attendance note, which is actually another assessment. And this is the part where I actually remember the last tip for the client interview, which is you need to be the one in control of your interview, because sometimes what happens is the client could be a client who just goes on talking and talking, or who's just crying. Of course, I was lucky to not encounter that. So you need to be the one trying to take control of the conversation, and don't let the client control the conversation. So keep asking them questions and just be like, okay, pacify them if they're crying, and then be like, I'm just going to ask you a few more questions. I need, because I need these details. So that was my last tip for the client interview. I'm sorry for mixing things up. Great. So back to the attendance note. So the attendance note is an opportunity for you to demonstrate your knowledge of law, because your client interview is essentially an assessment where you are focusing a little bit more on your skills, because they're trying to see how you deal with a client. They're also trying to see whether you're actually able to collect the relevant information from the client. So you've sort of demonstrated to an extent the skills part. Now, attendance note is a note that you're going to be writing to the partner who you work with. So this is the part where you actually need to provide a legal analysis or a case analysis. Case analysis would be for litigation matters. legal analysis would be for business or property or wills and probate. So in your attendance note, so you're going to be given another sheet to write your attendance note. So that's where you can write the basic introduction, which is client name, time engaged, so the matter, details of the matter, and then you can write, and then you can talk about the annexure, which is please refer to the annexure for these details. Annexure 1, contact details of the client. Annexure 2, assets and liabilities. Annexure 3, family tree, etc. And then after that, you move on to what are the issues that the client requires information on. So these are the legal questions that you now need to deal with. So you write down the issues and then you go on to the analysis. And this is the part where you have to write about, let's say, all the knowledge of the law that you know, because you're trying to summarize, you're trying to tell the partner what you think is the answer to the question. And this is again where you need to use some of the tips that Asta just mentioned. You can try and use very lawyerly language, saying that you can mention certain sections. If you know the section numbers, please do mention them. Try and, again, this is an opportunity for you to demonstrate how much you know. So if you know any case laws which are sort of relevant, make sure that you mention them. And then you say, so talk about the law, and then you say, based on the above, I believe that this is what the position should be, or I believe this is what we could advise the client. Mm-hmm. So, these are the sort of terms that you can use to also protect yourself from negligent advice. Mm-hmm. So attendance note, and so the last point is what I wanted to just emphasize on, which is time management. Because a lot of times candidates lose, they sort of run out of time while writing the attendance note. But if you've already prepared your annexure in advance, then you can just spend 5 minutes tidying it up. And then the rest of the 20 minutes you can focus on, your analysis. So I would just say that be a little aware of time while you're writing your attendance note. This is the part where I also I do remember running out of time. So you need to be, I would say, do practice mocks to understand how you can manage your time better. And I have a bad handwriting as well, so I had to be extra careful. And I'm not used to writing things down, so I had to make sure that my handwriting is legible. So that was the second problem that I personally had to face. Asta, do you have any points to add here for attendance note?
No, I think for attendance note, it's very clear. Is there anything you want to mention about the case analysis and the legal analysis? For business, it's a legal analysis, and for criminal, it's case analysis. Should there be a different approach? Or is the same approach, the name is different, you think?
I personally, I do remember there being a slight difference, but I mean, in general, the approach that I followed was similar. Mm-hmm. But I mean, do you recollect doing anything different?
No, but since you mentioned, I thought that you probably,
yeah.
If there was any difference, probably it's just the way it's.
Yeah, I think it's just a nomenclature thing, but yeah, I mean, I think maybe for litigation, you maybe the questions could be slightly different. You might have to apply a test, or you might have to, you might have to just
more emphasis on statutory provisions with the criminal and civil problem.
Yeah, and it could also be a little more focus on the procedures.
Yes,
that's what I would recollect. Yeah. I think it's essentially just a difference in terms of terminology. So you probably just have to use case analysis when you're, when you have a litigation interview. Okay, great. So the next part of the assessment is the advocacy. Advocacy is for litigation, and oral presentation is for business law and property or wills and probate. Now, the good news about this is that advocacy and oral presentation are not that complicated in terms of time management. So I never really had any issue, and none of my peers as well had any issue with the time management, because you're actually given 45 minutes to prepare, and 45 minutes is a lot of time. You have, it's enough for you to structure your presentation. It's enough for you to try and recollect what are the points you want to emphasize on. So advocacy, as long as you know the law, I would say that this is not really an issue. It's not rocket science. You just have to prepare a few notes and go ahead and present before a client. So again, advocacy in oral presentation, it's less conversational than the client interview. So let's say that if it's a business law presentation, then you would just have to go and, just maybe give a short introduction and then quickly just deal with the problem at hand. The decision maker, they may ask a few questions, but it's not going to be excessive, unlike your client interview. And if it's excessive, then the questions are a lot, then it might be a hint that you're probably going in the wrong direction, and that's why they're trying to steer you towards the right path. But of course, there's no one size fit all, but this is what I sort of experienced. I think for one of the presentations, I might have been going down the wrong path. And so I felt like the decision maker was probably trying to help me by asking a few questions and getting me on the right path. Again, for another point that I would also add to this is that for litigation advocacy, you would need to recollect or try to memorize and make these notes in terms of how to address the judge. So depending on the court that you're appearing, so if it's a district court, then I think there's a certain way that you address the judge. So make sure that you've collected those notes. Also, you need to memorize the tests. So more for either criminal or civil litigation, you would need to apply a particular test. So make sure that you've memorized the key tests for civil advocacy, and that's going to really put you in good stead. Is there anything that you need to add here, Asta, based on your experience?
Yeah, I think in general, I found it also very simpler than other assessments, so in terms of time, it is fine. It's just that you need to know a lot of law in advance. I mean, you should know a lot of law so that you are saying you're saying it out, whatever you know actually of the law, and of course applying it to the facts is very important. For me particularly, I did not face anything excessive in the exam. It's just we were taken a bit aback with the civil litigation, because we were asked something which was not is not a usual question. I wouldn't want to, of course, give out what was being asked, but still it was a bit unusual. So look out for all the applications in civil litigation, I would just say. Big or small, just look out for all the applications. Yeah.
Yeah, in fact, I would also add that I was also taken aback with one of the questions that we had received for business law. And I think that's where I might have given a bit of negligent advice, because I didn't know too much about the topic. I had an idea. So I started talking, about what I knew, and I felt like maybe I must have said certain things which were not entirely accurate. And that's why I felt like maybe the decision maker was asking me a few questions, and I think maybe she wanted me to get to a stage where I'm like, okay, I need to check, and I'm not really sure about the position, but I will need to do a quick check and get back to you. So this is, again, I think, an opportunity for you to show that you're a professional. So in case you don't know something, feel free to just tell the decision maker that I'm not sure about the position at the moment, but this is what I think. I will check back and get back to you on the accurate position.
Plus, what if someone is not getting a lot of questions from the assessor at the time? Should they be worried? Because once in my business, for example, I wasn't asked anything. by the assessor. They just noted down everything which I was saying, and that's it. So should I be worried if no one is asking me any questions?
Yeah, that's a good question. What I would say is, again, although this is more of a one-way street, this particular assessment, it might just be useful to notice if your client is nodding, make eye contact, because even though this is a presentation, in effect, this is something like it is actually in the format of a client interview, which is you're sitting in front of a client and you're explaining the legal position to them. So make eye contact, try and understand what uh, what you think the client might be, you know, understanding from your presentation. And you can also ask a few questions to the client in case you think that they're not being responsive. You could just be like, I hope that's clear.
Okay.
Or if you have any questions, just let me know right now. If you have any, I hope what I basically just um, try and engage your client. That's the word that I was looking for. So you can try and keep the client engaged while you're actually presenting. So that ways, in case you think they're not asking questions, you can just try and see if you can get them to interact with you a little bit.
Yeah.
Again, body language plays a big role, so just be like, okay, try and see, are they nodding? Do they look confused? Of course, sometimes certain decision makers are tricky. For my advocacy presentation, I had, assessor who had a very straight face, and I felt like she probably wasn't happy with me. But well, I think again, it could just be the case that it's an actor, right? She's probably putting up an act.
I think this is a very important point to realize that these are actors and they are given a cue, just how to, for them also how to behave in certain, I think in the client interview also, they follow a pattern. Some of them are angry as well, or they could be
Mhm.
straight face. It's just because they're following their instructions, right?
Yeah, but an important distinction that I would make is that for the client interview, they're actors, so they're not really lawyers.
Oh, yes.
They wouldn't really know anything about the law. The actors for the client interview, so they're just going to test you on how you can make a layperson feel. So I think the best person to actually do that is a person who's not a lawyer, right? Because you don't want to be talking too much legal jargon and getting them confused. Because some of them, when I was having a conversation, I actually realized that they didn't understand certain words that I was using. And then I had to just be like, oh, then of course I apologize and tried and tell and I sort of tried to explain to them that I'd give detailed explanation at a later stage, but you know the bottom line is there are measures to protect themselves. But on the other hand, for advocacy, I believe the decision makers, the assessors, they actually are solicitors or lawyers, because they need to ask you legal questions. So I think that's the distinction between client interview and advocacy.
Yeah.
Great. So I think that's about it for part one, and we can move on to part two. So over to you, Asta.
Yeah. Yeah, so for part two, I would start with legal research. During the exam, you will be given 60 minutes to complete the legal research online, and you will be given access to two databases. So it's either it's the two are LexisNexis or the Lexis Library, as it's called, and also the Westlaw. Yeah, so in the exam, you will be asked to do a legal research and given advice with legal reasoning. I will just go to it quickly. And just something to note is that, yes, Dave Kaplan will provide access to both the databases, but it could be for some technical issue that they are not able to give both the accesses, but only say of either Westlaw or Lexis, then you have to just make best use of the access which is provided at the time. The focus on this part is actually on the advice that it should be client focused and that you are actually able to give out the necessary authorities and sources, and your, of course, your advice has to be legally correct and comprehensive. And if there are any professional conduct matters to follow, keep a tab on that, and please write if you feel something about professional conduct which should be mentioned. Yeah. So yes, my approach to legal research was as following. I did not have access to both the databases. I took only Lexis library, but for Westlaw, I still wanted to have a feeling for it. I asked for a trial, and I think I got like a trial for 3 days or a week, just to sort of acquaint myself with how Westlaw would work. Should, of course, only Westlaw is available in the exam, but I was completely focused on Lexis library. When you go to the Lexis library, they also explain how to use the connectors. It's very important to be able to do your research quickly. So there are connectors like and, or, wn. So these are like short forms to find answers quickly on the Lexis library. Or Westlaw is also same. So you will find the explanation to the connectors and how to use them within these databases. In the exam, you will be asked to give a legal advice and legal reasoning. So your answer sheet should be divided between two parts. One, the topmost is the legal advice, and the bottom is the legal reasoning. In the legal reasoning, they are looking that you have researched using LexisNexis on the relevant case laws, on relevant authorities, sources, and also on that you have, if there are any statutory provisions to follow, that you've also quoted those statutory provisions and you're looking at the right places. Another approach, because this assessment is only for 60 minutes, what I did, now I will share it with you guys. I read the question, like it took 6 to 7 minutes to read the question. Some of the, because if the question is very big and I wouldn't want to go back and forth, I just during the exam you will be also given a rough sheet. So I made some small notes to recall when I'm doing my legal research. I think that is something really was useful. So I did not take more than 6 to 7 minutes or between that time to read my question. Then I, of course, looked up the LexisNexis with the help of connectors, try to research on the Lexis library for commentaries, for case laws. And when I found something which I thought was relevant, I started putting already in my answer sheet in the legal reasoning section. So I save time and I don't have to, towards the very end, I don't want to write my legal reasoning. So I would just use the, when I'm doing my research, also try to type in my legal reasoning part, how I am going about my research. I think that also saves a lot of time. When it comes to the question, it could be one question or it could be multiple questions. Just to keep in mind that uh, if you find one answer, just start writing, because to write, it takes a lot of time. So I divided my, I only gave 20-25 minutes to research, and then last 20 minutes to writing. So I think it's very, it is 60 minutes sounds a lot, but it is like a very short time in to cover legal research, also to divide your answer between legal advice, legal reasoning, to cover all. I think I found it particularly hard, this part. And what I've also seen from others, also my peer and myself, that we get all so consumed by part one that we kind of try to avoid part two, and we keep it towards the very end. But I would just say to anyone who's now attempting July session, that research one or two questions and try to follow the 60-minute time and attempt some samples. There are samples available on Kaplan website as well. That I found really useful. Probably a bit less hard than the exam, but I found them really useful.
Yeah, I think
Your thoughts as well on legal research.
yeah. Yeah, I think definitely legal research is one of the challenging parts of part two of the OSCE. Because sometimes what happens is they ask you multiple questions. So I do remember that I was once asked like about 4 to 5 questions, and then that can be a bit overwhelming. Of course, it's another thing that all those questions would be related to each other. So what sort of helped me was one is writing my answer in the form of bullet points, because
Mm-hmm.
what happens is when you write things in bullet points, and you don't really need to follow any paragraph structure or anything like that. You're just listing things down, and that what also that enables you to do is, as you research, like, you can just put snippets of information in your memorandum, and then towards the end, when you're organizing your memo, you can just all the snippets, you can just make them bullet points. Also, for each question, what I would do is I would divide it into legal advice and legal reasoning. So for the legal advice, I would say, okay, the question is, what is the limitation period? I would say this is the limitation period, or I believe, let's say if I wasn't 100% sure, I would just say that based on my research, the limitation period is likely to be, let's say, 5 years, owing to the following reasons. And then I would put everything in a point format, like in a bullet point format. And then for the legal reasoning, what I would do is I would sort of mention the keywords that I've used. I would also mention, and I would again follow like a structure. So keywords, then I would mention legislation, because that's a primary source for research, right? So I would mention the legislation. So let's say it's a Limitation Act, and I would also reproduce the section that I referred to. I mean, this is just to, again, make it seem a little bulky and seem like, I've done my research. If there's a case law, then I would, followed by the legislation, I would also mention the case law. And I would also probably put in brackets saying that I've checked whether this is the latest updated, whether this is the latest case law or not. So I would just mention something like checked whether this is updated.
Yeah.
And then if there's anything else, I would also sort of just mention that in legal reasoning. So essentially, legal reasoning is where I just try and focus on all the sources that I've used.
Yeah.
And legal advice is where I try and give the answer and a little bit of a background to how I got my answer and why this is my answer.
Also, what helped? Sorry, go ahead, Prasha.
Yeah, sorry. So even when it came to legal advice, I would try and say that, okay, fine, Section 5 of this act says this, blah, blah, blah. Or like if there's a case law, then I would mention a little bit about the case law. And then I would say, based on the above, this is what my answer is, So again, what I'm trying to say is that have already a structure in your head in terms of how you want to address the legal research memo. So once you have a structure, all you have to do is, when you're in the exam, you just spend time on the research. So you don't have to spend time trying to understand what structure you're going to follow for your memo. So again, so if you have a question, just type legal advice, legal reasoning, put everything in bullet points, jot down the keywords. So as you're researching, you can actually type out your memo as well.
Yeah.
Another point that sort of helped me was, again, the distinction between Lexis and Westlaw. Westlaw is actually good for case laws. So what happens is sometimes in Westlaw, they give you very good summaries of case laws. So what you can do is you can just copy that and paste it into your memo,
Yeah.
Of course, you just have to paraphrase it a little bit here and there, but there's nothing wrong in copy pasting. So that's one of the things that I found Westlaw useful for, which is case laws. Lexis, what I found useful was it has Halsbury.
Yeah.
It also has, it's a little more easier to navigate in terms of all their resources and commentaries. And also Lexis on their front page. Now, I don't have access to Lexis anymore, but on their landing page, from what I recollect, they had a section called glossary or something similar to that, where you can just type out a phrase, and what they do is they give you the definition of that phrase. They also give you the legislation where all that, where that phrase is sort of originated, and they also give you the cases which are related to that legal term. So for example, let's say you're searching for easement, most likely you will not be search for easement, but let's say you do search for easement, then you'll get the definition of easement, you will get this the law where it's referred to, and you will get all the case laws. So you can actually copy a lot of that onto your memo. That's what I found useful. And I found this useful for legal writing as well, because
Yeah.
sometimes when you want to just explain a concept, you can't really get the right words. So you can just go to the glossary and get that definition and copy paste it onto your memo. Um, so yeah, I think this is what helped me for research, which is having a structure and using bullet points. And of course, you need to practice as well. And I guess one last advice that I would say is that some of the questions in legal research are very bizarre. So make sure that don't get thrown off, don't get scared, or don't get panicked when you see these questions, because that's the idea of legal research. They're going to give you a question which is a little strange, which is something that you haven't really studied. So you have to do a little bit of research. You have to put that extra effort to find the answer. So I would just say that if you see something complicated, don't get panicked. Be prepared for some crazy questions. But if you use the right keywords, you're most likely going to find the answer.
Yeah, I also remember there was a question on a law which we didn't study, for example, competition law, or but I think their idea is that they want to see how you really do the research on LexisNexis, and so they're really looking at the legal reasoning part, is what I would say that it's important. I think out of legal advice and legal reasoning, I think you should keep writing your legal reasoning. Do not miss that. Even if you, due to time for one question, you're not able to complete your answer, and if you've written your legal reasoning part completely, like for that part, I think you will still get a lot of marks. Yeah.
Yeah, I think they probably just want to see how you've done your legal research. So again, dividing your legal reasoning into different parts also helps. So you have legislation, case laws, keywords, and on legal and on Lexis Library, I think you get the source. So each time you go to a commentary, you get to see the path. Yeah, there'll be a link that you get to which shows how you arrived at that particular chapter. So what you can do is you can just copy paste that link and paste it on your memo.
Yeah. Um, for me also, I looked at the commentaries before the exam. So when I was doing the practice part for legal research, I also took note of which commentary is better for a particular subject. For example, I found Butterworth's for company law really effective vis-a-vis Halsbury, or for cost, Cook's book on costs. And I think if you have a fair amount of idea when you're practicing, I think it will just save so much time.
Yeah, that's true. Like I said again, I think knowing the structure and knowing where to look for information would be very useful. So practicing definitely helps. Do you want to move on to the next slide? Yeah.
Yeah, so I think for legal drafting, again, you will have during the exam, you will have Lexis and Westlaw access, just to note. The entire legal drafting is for 45 minutes, and you will be asked um, to work on a document. It could be that you are drafting from a precedent, or you are asked to correct a document which has already been drafted, and you will during the exam, the focus is actually on how legally correct your answer is, and it's comprehensive, and of course the professional conduct matters to be considered when you are drafting. I think for me, for drafting, I really looked at each subject and looked at what are the forms and precedents which are asked in the exams before. For example, for a criminal, I know, okay, defense statement been asked, or application for bail has been asked, or application to admit hearsay has been asked. So I just each subject I really looked up all the forms and I drafted it myself. Good part about LexisNexis is that they have a section. I am not sure about Westlaw, Yash, I can't recall, but LexisNexis, they have a section called forms and precedents. And you can already, if you're practicing, you can already look up those forms and precedents. And it really saved me a lot of time in business. For example, if you're asked in business to draft a resolution, you will not lose marks on silly matters, which you can always look up on the Lexis library. Take out the form for how to write a resolution on a particular matter, and you will just, it'll be so comfortable. I found it really useful to practice from Lexis already, from forms and precedents. Yeah.
Yeah, I would say the same. Most of the forms and precedents are on Lexis, and that's what I also sort of relied upon. Even for like civil advocacy, if we had to draft a particulars of claim, let's say for a certain matter, and I just quickly looked it up and I understood the the format, and that definitely helped me for the drafting session.
It also gives you a sort of confidence that you're following a particular format, and you're at least you're not making silly mistakes. You're just focused on content. I think that was for me a lot of confidence booster during the exam, to have a source on like this. Yeah.
Another thing, now I don't know whether it was just me, I could be wrong, but before the assessment begins, you still have access to Westlaw and Lexis, because the computer is open in front of you, and both Westlaw and Lexis, they're on. So I think, let's say before you start the assessment itself, you can actually just go and scroll through the forms and precedent. So let's say if it's a property one, you might just want to go to one of the property law books and just keep it open, so when you start the assessment, you're not spending time. Of course, I don't know whether, like I said, whether this is allowed, but I mean, for me, like since the websites were on, I just I thought that it was okay to access them.
This portion of legal drafting, I did not find it really hard. I found legal research harder, I think. It's because when you get the forms and you're finding it on Lexis, for me, I think 50% of the task is sorted, because you're having something to look out for, and then you can really draw inspiration from that particular form, and then you have to only focus on filling a form. I think there are number of also on the Google, you can find very many forms and precedents which have been asked in the past. For example, for property law, form TP1, TR1. For criminal, also there are only a set of 10 forms you have to fill in. Yeah, so I got really very much questions which were predicted. So I did not face any trouble.
Got it. Yeah, I would just say that sometimes things can be a bit straightforward and there'll be a slight twist. So keep that in mind when you're going through the drafting exercise. So for example, for oath, for wills and probate, you're definitely most likely going to get an oath for administrators, or oath with wills and extra with letters of administration. So go through them in detail before the assessment, I would say. I think you would find a format for these oaths on the OUP books if you have them, or you can also maybe even find them online. So try and be super familiar with all of this, so that in case there's any trick question, or if there's any sort of tricky part, then you can actually address it in the assessment. Because I do remember that if something is too straightforward, then maybe there could be a little bit of a twist here and there. So and what I would just say is that make sure that you're familiar with all these formats beforehand. So once you're familiar with it, then you'll actually be able to catch if there's anything that's a bit unusual, or if there's any trick question. That's all that I would add here.
And I also think there are forms backside of the OUP book. I think for each book you have all the forms. At least I remember for criminal, they have all the forms backside of the OUP books, which I found really useful. And I had a bit of time, so I did all the forms with my own hand, like before the exams. I did practice all of them once before the exam at least.
Um, yeah, okay, perfect. Great. So I'm a bit conscious of time as well because we need to take question and answers. And I know I don't want this, so should we move on to the next
Yeah. So
assessment?
for legal writing, you will get 30 minutes and you have to give advice. So the advice could be either to the partner of the practice or to your client. And if it is, and accordingly, you have to tailor your advice. So if it is a client, then it should be not really, it shouldn't use legal jargons. And if it is for partner, of course, you should use certain words um, which you can use it with your fellow lawyer, right?
Yes.
Um, I think for me, again, I think Priyashi you already mentioned having access to legal databases was really useful because I did use out of 30 minutes, I did use 5 or even 10 minutes to look up. Um, look up the answer on Lexis, maybe it was really helpful because then I'm pretty sure of what is the correct law, and then I can focus on the legal advice part confidently. If it is for the partner, you can obviously copy the text from the resources. I could copy the text directly from Lexis. Some of my peers during the exam told me that they were not able to copy, so just note that I
Okay.
was able to copy, and so it should
I
be,
was able to copy too. Yeah,
yeah.
sorry, I was
So
able to copy.
the usual is to be able to copy, and if it is an exception, just talk to Kaplan. Then why you're not able to copy? Yeah, I think legal advice is a very straightforward in terms of format. So they will give you all the format in terms of the date is mentioned and like who is it addressed to. It should be mentioned. If not, then it's standard format of writing a letter. And then and if it is a client advice, then how you end it is also important. Like if it is a client advice where you will continue a dialogue with the client, then you can in the end you can say like we can have a further conversation about this particular matter, and I hope your I believe my advice is useful and I'm happy to talk to you again, or something very friendly on how you will write a letter or an email usually to your client. I would follow that style. Yeah, and just be careful on which kind of work imperative you should use. It should be, don't use should when you use a must. As Priyasha mentioned about the liabilities, better to use words, sentences which starts from I believe. Yeah, and the standard use short sentences whenever possible with active language, and that, yeah. And yeah, if it is a professional conduct matter which is likely in the legal writing part, I feel, then address that also in your advice. If you are very good with the LexisNexis, I don't think there should be any problem in terms of the law part. And I don't remember this section to be particularly difficult as well. So I found it easier to handle compared to legal research. And there are samples
Hmm.
on the Kaplan website as well.
Yeah, I would say the only part where I thought it could be slightly challenging sometimes is the fact that you only have 30 minutes. So again, it would not be challenging if you know where to look for information, but if
Mhm.
you don't, then 30 minutes could be a problem. Again, before tackling legal writing, try and again have like some sort of a structure that you normally follow for your letter. So again, if you keep that in mind, then it will save you some time. Also, I use the glossary section, like I just mentioned, for Lexis Library, which is on their, I think it's on their front page, where you, let's say you're searching, if it's a question in, again, let's say section 100 of some act, so that of let's say one of the criminal procedure law, you can quickly get some information, or Turnbull guidelines, for example. You can just search for Turnbull guidelines and you'll get pretty much a huge text of all the relevant information. You can just copy and paste it to your letter. Again, if you're writing to a client, then try and cut down on the legal jargon. But at the same time, remember that you're also being tested on the law. So you have to make sure that, you know, you are demonstrating the fact that you actually know the law as well. So these are the few key things that I recollect for legal writing. Another thing is sometimes the questions can be a little long. So make sure that you scroll through and quickly skim through the question in 5 to 7 minutes, or maybe even lesser than that, because I do remember for one of the writing exercises, I had missed one whole sheet of paper. And I only saw that, you know, one whole sheet of the question. And I only saw that, like, let's say maybe around 10 minutes before the legal writing assessment ended. And I sort of like, I was a bit thrown aback. And then I quickly went through it and then tried to do whatever damage control that I could. But of course, one thing that I do remember is that sometimes they give you a lot of information and not everything is relevant. So I think from that perspective, I managed to salvage the situation, because in a way it was good as well that I didn't go through all of that, because not everything is relevant. So yeah, I mean, that's one thing that I would just ask you to keep in mind, that if the question is really long, you just try and understand the crux of the question, and then you can type out your answer, because not every information could be relevant.
But monologue here.
What you mentioned about the 30 minutes is
During qualification, and I'm due to sit my final exam in a few weeks.
Sure, go ahead. Yeah.
So I think it's important to just practice with 30 minutes now as well, just to have a feeling for that you are able to cover the question within the time period. I think it just gives you a feeling for how you will approach it during the exam. So I don't think you should wait for the exam to write that within 30 minutes. I think you should practice now as well. Just one legal writing with the sample on Kaplan. Yeah.
Okay, great. So let's move on to the next part, which is the marking criteria. Asta, you want to cover that?
I would leave it to you to cover that, maybe.
Okay, great. Yeah, so I mean, I'm just going to briefly go over this. Essentially, you know, while they're calculating your total score, they're going to look at not just your skills, but on the law as well. And one of the things that I've noticed is that, you know, the clients who often like don't qualify the assessments are those who, they generally score really well on the skills part of it. It's just the law part is where they, you know, they score low, you know. So this is where I would just say is that demonstrating your knowledge of law is very important. And skills, more often than not, especially if you're a practicing lawyer, you would have it. So you just need to definitely, when you're practicing your mocks, focus on your skills, but also more importantly, remember that you need to show that you know the law. So, you know, remember the assessments where you have to demonstrate your knowledge, which is things like your attendance note, your advocacy presentation, those sort of things. And part 2 is essentially, well, anyways, mostly it's all about showing off, demonstrating your knowledge. And then another part is that you have 18 assessments. I think if you don't really do well in one of the assessments, don't get bogged down, because you have, I think they look at the average of everything. And from what I understand, they also don't look at any subject specific scores. So it's more like they look at all your assessments together, and as long as the average is passing, you pass, based on an average, you sort of qualify the assessment. So if you've messed up one of your assessment, I would say don't worry about it. All of us have messed up something or the other during the OSCE. remember that, you still have more assessments to go, and the exam is not over until the last assessment.
Yeah.
So you can still make up for it.
I can really vouch for it as well. I really thought one of the assessment, it's the end, but next day I really put myself, and then it was okay, I think overall.
Yeah, this is something that everybody goes through for the OSCE. Okay, great. So these are our last D-Day tips before we move on to the question and answers. Definitely, I mean, these are basic. This is basics, be calm. Second is arrive at the center well in advance, particularly if you stay away from the center or if you're using public transport. Because I do remember one of my friends, she was staying away from the center, and one of the days the public transport did not function.
Mm-hmm.
So she was in a bit of a pickle, and she took an Uber, and by the time she arrived at the center, the gates had closed. But somehow she managed to, beg and plead, and they allowed her to write the assessment, but they did tell her that we're not sure if this is going to be counted or not. So yeah, that's a bit of a horror story, especially for an international candidate, when you spend all that money to come to London, and then you don't end up reaching the center. So make sure that you arrive at the center well in advance. And again, if you're an international candidate, I'm guessing in this case, no, because July would just be for all those who are actually in the UK. But try and make sure that you know your assessment center prior to the D-Day. So try and see if you can visit the center, and that relieves a lot of stress. Again, this is a repetition of what I've said. The assessment isn't over until the last one. So you can always make up for something if you feel like you've messed up on one of the assessment. For part one of the assessment, you probably would already know this, but I'm just stating the obvious that, wear formals. For the day that you have an advocacy, which is a litigation advocacy, then try and wear like a white blouse or a pastel colored blouse and a blazer as well. In all the days, I anyways wore, like a blazer and a suit. So I was sort of in my formals and for all of the assessment days. For part two, you're sitting in front of a computer, so you can just be dressed in whatever way that you want to. Another tip that we have is if you need any special arrangements, try and inform the center in advance. Like for example, I do know that if you are pregnant, then you are actually given a little extra time. And one of my friends who actually was during that time, she didn't know it. So unfortunately, she couldn't really enjoy the benefit of that. But I was just thinking that if she did know that sort of facility, then it would have actually saved her. She would have gotten extra time, and it would have been so good for her. So I would just say that yes, we need special arrangements, especially during now that it's COVID. Many of you might need it, so try and inform the center in advance. Great. So we're actually now to the question and answers part. I'm going to stop sharing my screen, and we're now going to scroll through the chats. Let me open it. I'm sorry, it would have been good for me for us to take it towards the end, but then it would have been difficult to administer the session with addressing questions during the presentation. Great. Okay, great. The first question is gap between MCT and OSCE. Should we hurry, or would SQE be not life-threatening? Okay, I'm not sure if I understood the question, but I would say that if you've taken the MCT, then yes, you should take the OSCE and make the most of it, because the OSCE is certain. SQE is also something that I would say it really depends on your situation. If you're a practicing lawyer and if you really want to take the OSCE right now and qualify as a solicitor, then now's the time. But if you're more of a student and you don't have the funds to fund your QLTS, then it might just make sense to wait for the SQE, because there is going to be a transition period and there will be an end to QLTS. So let's say that you've taken the MCT, but you're not sure when you can take the OSCE. Then you don't want to be stuck in a situation where you have to, because you couldn't take the OSCE, you now have to take the SQE. So I would say if you're not sure, then it might just make sense to wait for the SQE. Great. The other question is, these 10 minutes of preparation comprise reading the material they give us, plus any additional documents. And this annexure is essentially a blank page they give us in the room, and we can send it with our answer on the attendance note. Yeah, exactly. So it's like a booklet, you can say, where you can take down notes. This is separate from the attendance note booklet that they give you when you come back to the room to write down your attendance note. So this is which is why we're saying that you need to use this as an annexure. So this is where you can take down all the notes of the client. I mean, all the information that you collect from the client, and you can make this like an annexure. So it's not exactly a blank page in the sense that it's a small booklet, with information. I mean, where you can take down notes.
Yeah, and this is and this is where I was saying that you can ask for extra sheets already. So I think they gave only one sheet, and then you can ask for extra, and then you can use them as annexures.
Yeah. Like for example, I didn't really, for me, I didn't really feel the need for like an extra sheet because there were quite a few sheets in the booklet. And for my rough notes, I just used the last page, and I canceled it, when I was submitting it as my annexure. So I just like put a, drew a line and canceled it. Great. Another question on attendance note. For the legal evaluation and given the limited time, how important it is to have references to acts and case law? A general but correct approach to the law is enough? Yeah, I mean, I think, again, like I said, this is the opportunity for you to demonstrate your knowledge of law. So if you do know a section, please definitely mention it. And if you're quite sure about the reference. Case law, again, you don't really need to remember too many case laws, I would say, just like the really landmark ones. For example, for criminal, I would remember the fact that we have the Turnbull guidelines for eyewitness evidence. So I would definitely mention Turnbull guidelines. Or if there's a good character order, I would mention the R versus Y case. So I'm not saying that I didn't memorize too many case laws, just the very, very landmark ones. So I would say maybe 5 to 7 case laws per subject is what I probably would have memorized. Yeah. And more often than not, you will sort of encounter one of these case laws in your assessment. So, of course, if you don't know the reference to the exact case law and act, then I would just say that a general approach will also work. But the more you can, I hate to use this word, but the more you can vomit in terms of what you've memorized, the better it is, because you're showing that you know the law. Would you add anything to that, Asta?
Correct. I think it's not too many case laws. Only in criminal and civil, I found that especially in criminal, I think it's good to mention case laws, because then, yeah, I think it's also easier than for the advice, because maybe this is a difference between case analysis and legal analysis. That in criminal and civil, maybe there's more need to add case laws, but if you don't, I mean, then. But there are not too many. I mean, I did not do more than 10 for criminal or more than 5 for civil. So yeah, they're very limited, especially for business.
Yeah, business would be, I would say, more of references to sections. Like, for example, I would remember the section number for removal of a director, That's like an important section to memorize. Or buyback of shares, I would just like try and remember the section number.
Yeah.
The next question is on, again, attendance note. Is it true that in the interview itself, you already have to give some preliminary advice? If so, I wonder if the attendance note must record that preliminary advice, then expand on it, Or do I instead come up with fresh legal analysis based on the facts I collected during the interview? I'm a little confused because I thought the attendance note was simply recording everything I did in the interview, like minutes of the meeting. A very good question, because that's exactly what I was also under the impression of. I always thought that it's just the minutes of the meeting. And it's only when I started practicing the mocks and when I started practicing with other people, that's when I realized that, oh, I have to write something more than just the minutes of the meeting. So it was something that I was also quite taken aback, to be honest. I thought it was just, minutes of the meeting. But in your, to address your first question now, in the interview, yeah, you will have to sort of give some preliminary advice because the client is coming to you with a question, right? So for example, if it's a business law and the client just tells you something like, oh, I have a company and I'm getting an investor. I'm a little scared about, the investor selling off my shares to somebody else. So you might have to give like a little bit of preliminary advice saying that, oh, don't worry about that. We can draft a shareholders agreement where we include certain preemption rights, so you're giving certain basic information. Just like placating the client for the time being. Or similarly, even for wills, if you're talking about, if they have like a question on how to apply for a grant of probate, you might just give them certain basic information. So again, like I said, focus on collecting the information during the interview and just give them very, very basic advice so that you can just, manage their question. And the second part of the question would be attendance note. Yeah, attendance note, like I said, is where you have to expand on the client's questions. So in your interview, you would have tried to understand what were the key questions that the client has. And then in your attendance note, you will list those questions. And then you have to tell your partner, this is what I think, this is my analysis based on the law. So you talk a little bit about the law, then you say, based on the above, this is what I think we should advise the client.
Can you change,
Asta?
Priyasha, for example, if you've given an advice or preliminary advice to the client, and when you're writing your legal analysis or the attendance note, you realize, oh, I have to change my opinion. Can you change it? What do you think, Priyasha?
I think you can change it a little bit because that's what I recollect doing it, because attendance note is again a separate part of the assessment. Again, the decision maker for the client interview is the lay person, right? So who's not a lawyer. They just want to see how, how you're sort of dealing with clients. I think it's fine to change it a little bit. I do recollect for myself, I did change my legal analysis a little bit during my attendance note. I suppose the lawyer who's checking your attendance note will also understand that sometimes it is possible that the actor could have misunderstood something you've said because he's not a lawyer, right? So I don't think they're going to go back and check with the actor what you probably told, the actor. They might look at your recording perhaps of, your interview, but I would think that they're not going to go to that extent unless it's something, unless the actor is saying something totally different, what, in terms of the advice that you provided, and your attendance note is saying something altogether completely different. So I do think that you can definitely change things a little bit. There's no issue with that.
I agree. Yeah, completely.
Yeah, because I definitely recollect changing. And as it is in your interview with the client, you're not really giving too much of advice. You're just giving very basic advice, preliminary advice. And like, if you don't know anything, just tell the client that, I don't have this information at the top of my head. I will get back to you once I've had a detailed look at the review of your case. And in any event, you're going to tell the client beforehand that the objective of the interview is to collect information.
Right.
You want to take the next question, Asta?
Sorry, it was scroll
This is
down.
question from Janelle.
For the
For the oral,
yeah.
yeah, go ahead.
Right. For the oral presentation, maybe business law, if I am presenting to the client, am I expected to state case law or sections of the act? I had the same question during my business, and I don't. I think I do recall telling everything to the client, not to the extent of case law, but I did remember mentioning the sections that if it was duty of director, for example, you can briefly mention it just to demonstrate your knowledge of law, but I wouldn't go into deep case laws because I mean, you're dealing with the client, and if you mention the section, and in business, for example, there are not too many case laws. It's a thin line to tread, I would say. Mention the case law, the sections, but don't go too much into detail. It could be one of the reasons that the assessor did not ask me too many questions because I mentioned everything I knew. It was a simpler question, business only. The other oral advocacy was a bit harder, but I do remember mentioning the sections at least and everything what I knew.
Yeah, I would just say that for business law, case law would probably be irrelevant because there are not too many cases. Just the sections of the acts would be sufficient. I don't remember, to be honest, memorizing any case law. Maybe just a few, one or two here and there. You want to take the legal research question? Yeah.
For legal research, in the legal reasoning section, did you just copy and paste the applicable law, which was then applied to the facts in the legal advice section? I think we did cover it, that in the legal reasoning section, we mentioned 4 bullet points, keywords, the law or the statutory act. Then we mention the commentaries or sources, and then if there are any case laws. Applicable law, you can and cut copy. Yes, do feel free to cut copy in your law part or the section where you want mentioning the statutory part, but I would also mention the sources, the commentaries, and also keywords, and also the case laws if there are any, and also the footing of
Yeah.
the
Yeah, I think another tip that I recollect what I did for legal research was, let's say if I reproduced a particular section, so let's say I reproduced section 5, what I would do is I would underline the relevant part, or let's say that I was copying summary of a case law from Westlaw. I would paste it onto my legal memo, and then I would underline the part which is relevant. So I guess it again shows it highlights to the decision maker the focus of my research, so they would understand that, okay, fine, this is what she's looked at, rather than and she's sort of making it easier. It's easier on the eye for the decision maker.
Would you say in legal reasoning then quantity over quality, or how would you say?
I would say a mix. Quantity helps because you're showing the decision maker that this is the research you've done, you've looked at so many sources, so quantity definitely would help. Question on legal drafting: is there a place where we can find a list of all documents we will likely need to draft for each subject in the OSCE?
The book also have them towards the back side of their textbooks.
I see. Okay. Yeah, I don't recollect that, but that's a good tip. We're also, to be honest, trying to compile a list where we can put it up. And I mean, like I said, our application is not yet running, so unfortunately, we can't share that yet. The next question is, in legal drafting, does Kaplan give you the form you have to fill, or a few options, or you're supposed to find the relevant form? Good question. Sometimes they do give you the form.
I was in most of my assessments, I was given the precedence.
Yeah.
But in business, probably they won't because it's if it is a resolution or if it is civil, if it's particular of claim, then there is no sort of format of which they can give. Then it's helpful to look up the LexisNexis library. Yeah.
Yeah, actually, what I recollect is that they do give you a framework. So even for us, if it was particulars of claim, let's say example, they would give you like the basic page with a few things filled up, and you just have to then fill in the blanks. And or even for like a resolution, I think they would give you certain basic
We
details.
were not
And
given for these two.
uh,
We were given.
okay. So like I said, it really depends on case to case. You have to
So it's
probably find
handy
the form.
know it where you can
Yeah.
find Nexus. Yeah.
I guess it depends on the difficulty level. In fact, if they give you the form, then you probably have to be a little worried because it's probably a trick question and you
Yeah.
need to
Yeah.
use your mind to make sure that it's just not a simple fill in the blanks, you know?
Mm.
So there could be certain tricky parts, tricky elements to the question. Okay, I think there's another tip out here in terms of uh, those who have subscribed to QLTS School can probably benefit from that.
This is an interesting one about the, I can take it from Janelle. Is it necessary to memorize law from the MCT areas or just a general understanding is all right? Okay, I think in the beginning, I did not realize how important it is to recall from MCT. I do think you should look at for criminal from the MCT part was really helpful, and for civil, I would say contracts and torts. Just to skim over the MCT areas for contract, torts, and criminal, I really think it was really helpful. So not to miss those parts from MCT. So I would just say contracts, torts, and criminal.
Yeah, I think certain basic things it would be useful to go back to your MCT
Criminal defense is
syllabus.
not really explained in the that in detail in the OUP, and the defenses could be really critical in the attendance note and your client interview, and just in general, I think yeah, some parts definitely they are coming from NCT. Yeah.
Yeah, we will share a copy of the webinar, so watch out for that. We'll send it to you post the completion of the webinar. Will there be, for part 2, there will be a question for only one of property and probate, for example, or both?
I had a very different experience. I had I had three of them on one subject without mentioning which subject, but I had three of the part two on one day on one subject.
Oh, okay, that's strange.
There was one part which was a mix of both the subject, but
Mm.
definitely it was three of them were from one area of law.
Okay, yeah, that's strange because sometimes I was always under the impression that they try and balance it out. So, for example, if it's litigation day for part 1, and they give you, let's say, civil for interview, you might most likely get a criminal
I
for
think
your
part one is
advocacy.
definitely you will have the division is like if it is criminal, then it's either client interview
Mhm.
or advocacy. But for the writing part, I think, or at
Yeah, I
least
think,
three, there were two. There was something I recall. There were either three of them were from one subject area, or just they were just mixed altogether. So that was kind of shocking. Yeah.
yeah. In fact, I've just shared a link to a YouTube video, which is the Kaplan's video on what to expect on the assessment days. So I found that useful just to have a look at it because I would definitely say have a look at it, and it shows you bits and pieces of what you can expect on the assessment day. So it's useful to have a look at that. I've also shared another article that I've written on, how I prep for the OSCE, and that has a few details of what we've covered during the presentation as well. So I've just shared that. It's on LinkedIn as well. Yeah, I think that we've covered all the questions. I think the last question as well, we just covered it. Is there just a question to all of you? Is there any other topics for the MCT that, I'm sorry, for the OSCE that you think might be useful for us to sort of get into sort of more detailed? And then maybe we can think about conducting a session at a later stage, but just curious about any part where you think certain details might be useful.
Do you want to unmute?
Oh, I could actually unmute.
You can raise hands, right? If someone...
if you have any specific question, you can raise hands, or if you want to discuss anything, feel free to just ask us. Because I think we pretty much reached the close of our presentation. So if there are no further questions, then we will share the webinar with you. Itemized. Okay, I think it would be. I'm just having a look at one of the comments. I think it would be useful to have an itemized list of what are the main contents that are usually asked. As is, we have just all the law.
Yeah.
Yeah, I think, definitely. I mean, I think that's where the notes come into play, where all these cheat sheets and summaries in terms of, so I mean, I suppose if you, when will you be offering OSCE mocks? At this stage, we're not, but we're definitely going to be sharing our, subject notes. In fact, that's one thing that unfortunately we're not able to release right now because we still have a few technical glitches with the app. But things like an overview of each of the subjects and stuff, we've actually sort of prepared them, and we just need to release them via our app. But that's what we would essentially do to make an OSCE candidate's life easier.
Also on case laws, like we see a lot of questions on case laws.
We have case law lists and all of that.
Yeah,
okay, I agreed. I think that's about it for today. And if you have any questions, then you can email us as well. And we're happy to address them. And we wish you all the best for the OSCE. It is a intimidating exam, but I'm sure you'll all do very well. Maybe the competition might just be a little less, considering that it's COVID, so they might just be nicer to all of you. Okay, perfect. So thank you, everybody. We will share the presentation with you.
Bye-bye.